Hello everyone and welcome to our lecture recording for chapter 11. Today we're going to continue with the same substantive area which is of course contracts, and we're going to continue in the second uh, part of the analysis. So once we have completed our discussion on the existence of a simple contract, and we have assumed that there are no issues with the questions of agreement and intention, i.e. intention to create legal relationships, and with the issue of consideration, keep in mind of course the possible exceptions such as estoppel, promissory estoppel. We can now move on to the second part of our analysis that relates directly to the validity of this contract that we have. So today we're gonna look at the capacity of the parties to enter into a contract. So as it is explained on page 280, it says capacity, or perhaps more accurately described as incapacity. So this is the first paragraph. If you drop to the fourth line, it says capacity, or perhaps more accurately described as incapacity, refers to the ability of the parties to a contract to fully understand its terms and obligations. However, it says under both common law and statute law, there are certain types of people who are considered to be incapable, either partly or wholly, of doing so. Those classes of persons are subject to varying degrees of incapacity, raising the question, which we will look at as step 4 in our analytical framework, of whether they understand what they are entering into. So as usual, we're going to cover the chapter through the learning objectives, which for this chapter, chapter 11, are given to you on page 279. And we'll start with the first objective that asks us to explain capacity to enter a valid contract and recognize some individuals' restricted capacity to enter into contracts. We have already looked at this idea of capacity, what it means. Of course, this is only the first step in our analysis of the validity of contracts. So later on, of course, we will look at other issues that may arise, but that's coming in the next steps 5 and 6 in relation to validity of contracts. So for step 4, as it again says on page 280, only a normal, sane, sober, adult person has full capacity to make a contract. So if you're not normal, so you have psychological or psychiatric problems, or you are crazy, not sane, or you are intoxicated, not sober, or you are a minor, okay, a child, or someone who's below the age of 18, then you don't have that full capacity. All right. So again, this means someone who has capacity to contract is someone who has the ability to understand what is they are entering into. Okay, that's the key point. So once you have this ability to understand, then we can talk about the ability to enter into an agreement, for example, or to have an intention to create a legally binding relationship. So this is why it's important to make sure that you have this full capacity to contract. So then some classes of people, as we said, are treated as not having this ability to understand fully what it is they are entering into. And you will have a figure 11.1, again on page 280, that shows you these limited capacity to contract categories, and we want to emphasize that they are basically limited, as opposed to having the full capacity to contract. So this is the key point here, that they have limited contractual capacity. So we have these 5 categories. We're starting with minors and then going through to talking about corporations, bankrupts, the mentally ill and the intoxicated person. Okay, now let's go back quickly here. Again, we say only these people, the person who's normal, sane, sober, an adult, is the one who has full capacity contract. And under common law, and in some states there has been modification under statutes, some class of people are treated as not having full contractual capacity, which means that this affects the validity basically of any contracts entered into by these persons. Okay, so if they are not normal, sane, sober, full adult, then the validity of their contracts comes into question. So that becomes a legal issue. Okay. Let's then outline the common law rules regarding contracts with minors and discuss classification of contracts for an infant. Okay, so we start on page 281. As it says, legislation in all states provides for full contractual capacity from the age of 18 years. So if you go to table 11.1 on that page, again page 281, for example in Queensland, you will have that there's something called the Law Reform Act of 1995. Under section 17 says that the full capacity contract has to be from the age of 18. Alright. Now, in Victoria, New South Wales, and in South Australia, in these three jurisdictions, okay, there has been a statutory intervention that made alterations to the common law position as it affects infants, and these changes are dealt with in more detail on pages 286 to 289. Now, in relation to infants, so this is what we were talking about in relation to the age of majority, and in relation to infants, then we can classify the contracts that they enter into, so these are people below the age of 18, as either valid, voidable, or void. Okay, the contracts they enter into could be classified as either valid, voidable, or void. And we can go back to chapter 7, in particular to page 195, under the third learning objective of that chapter, and you'll find that there's an in brief box again on page 195 that explains the classification of contracts based on what? Based on their enforceability. Based on their enforceability. Okay, so what we're talking about here really goes to the enforceability of the contract that already exists. So there's no issue, legal issue, with the existence of the contract, but there's a legal issue in relation to, in this case, that our lecture for today, in relation to capacity to enter into contracts. So enforceability then, and there are three categories we're looking at today: valid, voidable, and void. So as it says on page 195, a valid contract, all elements are satisfied and enforceable by either party. If it's voidable, only the injured party, so in our case here now we're talking about infants or minors, only minors can enforce the contract or rescind the contract. Okay, and if it's void, then there are no legal rights or obligations, so neither party can enforce it. So all of we're talking about now is about this idea of enforceability in relation to valid, voidable, or void. Okay, so again, the reason for this classification is twofold. First, that the inexperience of infants and their lack of judgment in business matters indicate that they should be protected from making foolish bargains. And the second reason is that the possible hardship that would result for adults who deal with infants if all contracts with infants were to be set aside must be, where practical, alleviated. So you are trying to balance this interests or rights of the infant to be protected with also the interests and rights of adults to be able to deal with infants without having to worry about, you know, having everything that they do with infants open to being set aside and not being enforceable. Okay, and you will understand this better now as we look at some of these categories and what attracts validity or voidability and so on. So let's start with valid contracts, which is also on page 181. If an infant pays cash for goods or services, they are bound. That's the first thing. So here you can see that we are really trying to prevent hardship to the adults that are dealing with the infants. If the infant has cash and they pay by cash or pay with cash, then that means we have a valid contract. It's enforceable. The infant cannot turn around later on and say, but I'm an infant and I can't pay for this, and so on and so forth. If you have the cash, then that's the end of the story, and we are going to prevent the hardship that would accrue to adults dealing with this infant if we don't enforce this contract. Okay, so if they pay by cash, the contract is enforceable, and you have more on that point as well on page 285. Cash transactions. Okay. Now the general rule, however, in relation to valid contracts says that at common law, a contract made by an infant is only valid and enforceable in only two instances. Yeah, the first one is where you have contracts for necessaries or necessities, and the second is where you have beneficial contracts of service. So if you have either one of these categories, we say that the contract is valid. Again, keep in your mind really this efficiency issue, because at the bottom of it, really everything that you read in relation to law, not just in business law or this textbook, everything could be analyzed in relation to law and economics. So the economic analysis of the law. So here we're looking at efficiencies. So why would we have these two categories valid contracts? So let's start by looking at the first one, which is the necessaries or necessities on page 282. On page 282. Okay, so let's continue with valid contracts, and it says the word necessaries includes articles and services essential for the reasonable comfort of the infant, as well as basic food, clothing, and shelter. So you can see if the infant enters in such contracts, we know that these contracts need to be enforced because they are for their well-being. See, essential for their comfort. Now, in the inbox, you see, in the in-brief box on page 182 says when are goods necessaries, because that's not going to be a static sort of standard. To be successful, i.e. the infant, the plaintiff must be able to establish 2 points. Okay, are the unpaid, sometimes of course the plaintiff would be the adult, because the adult is trying to enforce the contract against the infant. But going back to these 2 points, first, are the unpaid goods or services capable of being necessaries? This is a question of law, so this is something that's decided by the judge. Okay, and then are the goods of service or services necessaries in the particular circumstances? That's where you come to the question of fact, and we need to look at the factual matrix, or look at the actual facts in this case. Okay, so this involves looking at whether the infant is already adequately supplied. See, so if it is established that the goods are necessaries, the infant needs only to pay a reasonable price for them. So while this is going to be then a valid and enforceable contract, we also have to make sure that what they have paid for these necessaries is reasonable. Okay, and then it says again on page 282, what does a business need to establish for goods to be necessaries? Drop down 3 lines, it says to be successful, the plaintiff must be able to establish 2 points. First, are the unpaid goods or services capable of being necessaries? Again, the court has to first be satisfied that in the circumstances, so this is the abstraction, the question of law, in the circumstances, the goods or services are capable of being a necessary, and this is a question of law, as we said, and the onus is on the plaintiff to prove that they are, and if they fail, the case is dismissed. Alright. Now, if the goods or services are capable of being considered to be a necessary for the infant, then the plaintiff needs to go on and establish the second point, which is, are the goods or services necessaries in the particular circumstances? Here, this is a question of fact. This means considering the actual requirements of the infant and deciding whether the infant was adequately supplied with these goods or services at the time of sale or delivery. It may be necessary here to consider the social standard. That's the key point. The social standing or social standard of the infant and their occupation, social conditions, and other similar factors. And you have two examples there to consider, but the key point at the end is that even though we can establish that these are goods and services, these goods and services are necessaries, remember that, as it says on page 283 in the second paragraph, second line, the contract can still be void if it contains harsh or onerous terms. So again, go back and remember why these laws are made. We're trying to strike this balance between protecting the infant but also protecting the adults that deal with them. So if the contract is for necessaries, this is something to protect the infant, so we want to make it valid so that they get what's necessary for them. However, if they get what's necessary for them for or under a harsh or onerous term, like for example the price is too high, then that contract could still be found void. Alright. There's a risk management alert on page 284. It says a trader who supplies goods or services to an infant on credit, so this is not cash, does so at a considerable risk. If the infant is already well supplied with those articles or services, then the trader would not only be unable to enforce the payment, but in the case of goods, they may not be able to recover them unless the goods were obtained by fraud. Okay, so that's your risk alert in relation to dealing with infants. So you need sometimes to really establish the age of the person you're dealing with in order for you to make sure that they have full capacity to contract. Business tip under that says dealing with an infant in business. When dealing with an infant, a supplier of goods or services does so at a considerable risk. If they hope to be able to enforce the contract, then they must ensure that three things: the goods or services are capable of being and are necessaries. Okay, the contract doesn't contain any harsh or onerous terms, and the price is reasonable. Alright, let's then look at the second category we talked about earlier, where we have valid contracts. This is in relation to beneficial contracts of service, and that's found on page 284. Here these contracts could be things like contracts of employment, apprenticeship, training, or education, and can contain unfavorable terms. Okay, so the court will examine the contract as a whole, weigh the onerous or harsh terms against the beneficial terms, and decide, looking at the contract as a whole, whether the balance is in favor of the infant. So this is really the crux of the matter. This is the bottom line. These laws are made to protect the infant because they might not be able to fully understand what they are getting into in relation to agreement or a binding relationship. Alright. Again, while the benefit is the basis for the validity of this type of contract, this does not mean, as it says on top of page 285, this doesn't mean that any contract that the infant enters into and obtains benefits from will be enforced against the infant. Okay, thus a trading contract may result in financial benefit to the infant but will not be binding, and the example is given you right below that. Then there is a category of contracts that are valid unless avoided. Okay, so it says here in relation to what we call voidable contracts, the class of contracts involved in limited this class rather is limited to those through which the infant acquires an interest in some subject matter of a permanent and continuous nature. And the examples are given to us here on this slide. Things like the purchase and lease of land, the purchase of shares, or partnerships. Okay, so in this kind of contracts, when an infant repudiates a voidable contract, so they don't want to go through with the obligations on the contract during infancy, so while they are still below 18 years of age, or within a reasonable time after becoming an adult, so just 18 years of age. And what constitutes a reasonable time again depends on the circumstances in each case. So again, the point is, when an infant repudiates a voidable contract during infancy or within a reasonable time after becoming an adult, rights and liabilities that accrue after repudiation cease. So from the time that they repudiate this contract, so they don't want to continue the contract, they don't want to perform basically their obligations, and they are not interested in any relationship with the other party, then any rights and liabilities that accrue under the contract cease to accrue from the time of repudiation. So the infant will remain liable for any obligations accrued up to the time of repudiation of the contract, unless there has been a total failure of consideration. What does that mean? So you'll find that there are examples of that on that page. Where for example in Steinberg and Scala, there it said the infant must establish that the consideration has completely failed in order to succeed. So have a look at that. That explains what we mean by failure of consideration, total failure of consideration. Okay. Now there's a question there that says, can a business recover any money paid by an infant under a voidable contract? Can you recover the money that was paid by an infant under a voidable contract? So money already paid by an infant, so they paid so they paid money under the contract, for example, for the sale or lease of land and so on. Money already paid by an infant under a voidable contract is irrecoverable unless the infant has received no benefit from the contract whatsoever. And that's basically what we mean by a total failure of consideration. If the infant hasn't received any benefit whatsoever, that's what we refer to as total failure of consideration. However, it continues, we are on page 286, no matter what the subject may be, the courts are reluctant to find that the infant has received no benefit. Then there is a related category that talks about contracts that are not binding unless ratified, again on page 186. Now this category catches purchases of non-necessaries and trading contracts. Okay, so these contracts are not binding unless ratified. So these are essentially the only other classes of contract that an infant can enter into after taking into account the categories above. Here the contract cannot be enforced against the infant during infancy, nor after attaining majority, unless the now adult elects to ratify it. So these contracts that are not for necessaries, okay, if the minor becomes an adult, so they became 18 or older, they can ratify the contract. This is the opposite of repudiate the contract. So you can ratify the contract. You can say, yes, I will accept this contract for non-necessaries, and I will complete my promises or obligations under the contract. So this is where we say that the infant, once they achieve the age of majority, then they can ratify the contract. However, notice what they say, the second sentence. The next sentence says, but the contract is not void during infancy. So the contract is not void during infancy because the infant always had the ability to ratify it on attaining the age of 18. The contract is binding against the other party. See? And most states have now modified the common law position by statute, and you can go and refer to these sections in these statutes if you are so inclined, or you are interested, or you live in one of these basically jurisdictions. The third category we want to talk about is what we call void contracts. So this is where you have no rights and obligations whatsoever. Now in Victoria, for example, Victoria under this Supreme Court Act of 1986 makes void the following: contracts for payment of money lent or to be lent, contracts for payment of goods supplied or to be supplied other than necessaries, and accounts stated for non-necessaries, a debt basically. Okay, so there has been some modification of the common law position, as you can see here in Victoria. This act provides, for example, that no legal proceedings can be brought against a person who ratifies a contract at the age of majority. and avoids contracts made after an infant reaches majority to repay a loan entered into as an infant. You cannot actually take them to court in such circumstances. Alright, let's then look at our third learning objective for today, which says discuss the impact of statutory rules in New South Wales and South Australia regarding contracts with minors. We don't have to go into these in much detail because basically we're not really in any of these jurisdictions, but these are on page 287. Now the New South Wales Act says, or basically attempts to make infants liable in contract, provided that they have the ability to understand what they are getting themselves into, and that at the time of contracting it is for their benefit. So basically this act, the Minors Property and Contracts Act of 1970 from New South Wales, looks at the pragmatic application of this age of majority. So sometimes people could be 17 and a half, sometimes they could be 17 and so on, but they're still really able to understand what they're getting into, and they're still able to get a benefit from that. So that's taken into consideration. Okay. So the infants in such circumstances under this act in this jurisdiction would still be liable. Okay, so this is a modification of the common law rule. So this is really, I would say, more in tune with the 21st century, and this ability of young adults to really understand and benefit from getting into contracts at an age lower than 18 years old. Okay. Now there's also a civil act that says the act bases the contractual liability of infants, this is the contractual liability of infants, on the concept of a civil act. Okay, these civil acts are defined as being any act relating to contractual or proprietary rights or obligations, or to any shows in action. What does that mean? So shows in action really are simply property rights enforced through legal action. Okay, property rights enforced through legal action, such as rights of an employee to say their unpaid wages. Okay, so this is legal action to get their unpaid wages paid. That would be called a shows in action. Shows is just a French word, or coming from a Latin root probably, that says thing in action, and it's in action because you have a legal action to get that thing. All right. These include again contracts and dispositions of property, and there's a test whether it's a civil act or not. Is first, is it for the benefit of the infant, and whether the infant understands the nature of the act. Okay, and then there's the definition of benefit. Now benefit is not defined anywhere in this act. We're talking about New South Wales, although it applies to appears rather to be wider than the concept of necessaries considered earlier. So it's wider than the common law construct or concept of necessaries. It should be for the benefit of the infant. Okay. Then there are further categories at the bottom of the page. I'll leave that for you to look at. The same thing in South Australia. South Australia is not an extensive. The act in South Australia is not as extensive as that in New South Wales, but it basically leaves the common law untouched and incorporates only 5 specific recommendations of the Law Reform Commission of South Australia. So it leaves really most of the common law untouched, and you can read more about it again on page 288. Alright. Now a few points before we move on to the last learning objective, taking us back again to page 287. The first in relation to torts by infants. Torts by infants. And there it says infants are generally liable for any torts that they may commit, although they are not liable for a tort connected with a contract. Okay. So you'll find again in New South Wales that they abolished this rule. Okay, so that a person under the age of 21 who is guilty of a tort is answerable for the tort, whether or not the tort is connected to a contract. So if they deceive someone, for example, under contract, okay, and someone wants to sue them in tort for that instead of, for example, under the ACL, let's say, uh, then they could do so because this common law position has been modified by statute. Now there's another thing also, which is the tort of deceit. The tort of deceit, okay? So it says the infants are no more entitled than adults to keep goods obtained by fraud. So if they commit fraud, so dishonest representation of facts in order for them to get something, then the equitable doctrine of restitution, may be applicable, but only when the very same goods obtained by fraud are still in the possession of the infant. So if they sell them, that becomes a different story. But if it's still, say they got something like I don't know, a car or maybe a mobile phone, but this thing is still in their possession, then we can apply this equitable doctrine of restitution, which means the goods go back to their rightful owner. Alright, let's then move on to the last learning objective for today, and this is asking us to describe common law rules again on capacity to contract for other categories that we saw on figure 11.1, which are corporations, the bankrupts, the mentally unsound, and the intoxicated persons. And the study or the discussion of that starts on page 289, and it starts with corporations. So again, corporations are legal persons. Okay, they are legal persons, and hence they have the same legal capacity to contract as natural persons, and you'll find that covered under the Corporations Act of 2001. That's a Commonwealth Act, of course. And the key point is that corporations, the contractual capacity of corporations is limited only by natural impossibility when it comes to entering into personal contracts, because it is an artificial creation. Alright, then let's move on. As it says at the bottom of this slide again, if the company acts in excess of its powers under its replaceable rules or basic constitution, the other party may still enforce the contract under the Corporations Act, which is of course under section 124. Now for our purposes, don't feel obliged to go and check these sections. What's important is that you just pick up these clear points about whether a corporation is able to contract or not, whether it has a full capacity contract. The next point we want to talk about is bankrupts. And there, as a general rule, bankrupts can still contract, but their contractual capacity is limited, and it's limited by an act called the Bankruptcy Act of 1966. Alright, and I believe the current limit on bankruptcy is $5,000. So a creditor cannot make a person bankrupt unless the debt is $5,000 or more. Okay. What about then the mentally unsound and intoxicated persons? This is on page 290, and the same thing applies. It says there contracts with the mentally unsound or the intoxicated are usually regarded as being voidable at the option of that person, unless they are for necessaries. So very similar to what we looked at in relation to minors. The sale of goods legislation in all jurisdictions requires that mentally unsound and intoxicated persons who purchase goods that are necessaries must pay a reasonable price for them. So similar to minors, that's the key point. Drop down to the bottom of the under the table 11.2, it says where the goods are not necessaries, the person suffering the disability again may be able to repudiate the contract when they are again of sound mind or sober. If at the time of contracting they were suffering from such degree of mental instability or were so inebriated that they were incapable of understanding the nature of the contract, and this was known or ought to have been known by the other party. Alright, so that's what we just covered. And the last point really is just of historical relevance. Of course, the position today is that married women have full legal capacity, okay, but historically, of course, there were some issues with that, okay. And as it says at the bottom of page 291, where the parties are living together, whether as a married couple or in a de facto relationship, okay, the woman is able to pledge the man's credit for necessaries suitable to their style of living and arises from the fact of cohabitation, Alright, that brings us then to the end of our lecture for today, the lecture recording for chapter 11. Next time we're gonna look at the lecture recording for chapter 12 and move further in our analysis of the validity of contracts when we look at the issue of consent and whether we have a genuine consent or not. Alright, until then, I'll leave it there and talk to you again soon.